this is Preet Verma and this is video of international human rights. Prima facie, what is the meaning of international human rights and how did the concept of international human rights evolve? The Second World War had a profound impact on the development of human rights law, as there was a need for a system to give rise to protection of human rights. This led to a wide spurt of activism and literature on the same. In addition to this, Article 4 of the International Covenant on Civil and Political Rights, that is ICCPR, states that there are certain rights such as the right to life, freedom of thought, prohibition of slavery, etc., that are said to be non-derogable and constitute a special place in the hierarchy of rights. Also, there are certain rights that have also entered the framework of customary international law, like the prohibition of torture, genocide, and slavery, and the principles of non-discrimination. These have become certain inalienable rights that do not require any specific treaty to be given effect to. Furthermore, one of the most influential documents in this regard is the Universal Declaration of Human Rights, which deals with various provisions, a few of them being liberty of person, that is Article 3, equality before law, that is Article 7, prohibition on torture, that is Article 5, and socio-economic rights such as right to work and equal pay, that is Article 23, to right to social security, Article 25. Another such arrangement was the Vienna Declaration and Programme of Action 1993. It emphasized that all human rights were universal, indivisible, interdependent, and interrelated. This led to the creation of the post of the UN High Commissioner for Human Rights, who would principally be responsible for UN human rights activities. The High Commissioner can make recommendations to other UN bodies and can also coordinate between them. There are several other key legislations and arrangements such as the Convention on the Prevention and Punishment of the Crime of Genocide, the International Convention on the Elimination of All Forms of Racial Discrimination, which read with provision of the Universal Declaration of Human Rights, give rise to a host of enforceable rights in both treaty and customary international law. There are various bodies such as the Commission on Human Rights, which is known as the Human Rights Council since 2006. It looks into matters of human rights issues. However, it has faced criticism on its political selectivity and failure to objectively review the issues in certain countries. The Human Rights Council is continuing the work of the previously set up commission by broadening its framework by spreading its area over a wider framework. Now let's discuss customary international law. According to Article 38 of its statute, the International Court of Justice, whose function is to decide in accordance with international law, such disputes as are submitted to it, has to apply inter alia international custom. This source of public international law is described in the same article as evidence of a general practice accepted as law. But at the same time, international customary law is probably the most disputed and discussed source of international law. For example, it is not clear when a particular state practice becomes a legally binding state practice. It is also unclear how one can identify a rule of international custom or how one can prove its existence. Now there is another question that can international law be directly applied in the domestic jurisdiction? So in order to understand its answer, let's discuss international law and municipal law. So the interplay between municipal and international law is complex. Some authors believe that international law and the law of the domestic jurisdiction, also referred to as the municipal law of the country, do not interest and are completely different entities which cannot affect or overrule each other. However, in practice it seems that this does not hold true. There are some principles that are clear as this conflict between international law and domestic law is concerned. Municipal law cannot serve as a defense to a breach of international law. That is, you cannot use a domestic law to justify the breach of an international one. Neither can one say that their consent to a treaty has been invalidated by way of a change of its municipal law. Similarly, the International Court of Justice has also stated that the lack of domestic legislation cannot be brought up as a defense if there is an international obligation on the state not to do a certain act. There have been various cases on points that state that international law is prevalent over the domestic law. However, that does not mean that domestic legislations carry no force. Nonetheless, it is to be understood that each country has their own method of dealing with the application of international law to its jurisdiction. The provisions of international law are often used to supplement various propositions of the domestic law when they are both concurrent with each other. However, whenever there is a dispute between international and domestic law, supremacy of either depends mainly on the forum, that is, where the case is being contested. International forums generally give preference to treaty law and other international sources, whereas domestic forums give preference to status of the jurisdiction. So I believe through these sentences you guys must be confused. After all, which one is superior and which one need to be followed, especially when both the laws conflicting with each other. Believe me, the answer is not so simple as it entirely circumstantial decision. Now let's discuss the international law in the Indian context. So the scope of international law in India is very defined in the Constitution of India, as Article 51 specifically states that the state shall endeavor to foster respect for international law and treaty obligations in the dealings of organized peoples with one another. In addition to this, under Article 253 of the Constitution of India, the Parliament and the Union of India have the power to implement treaties and can even interfere in the powers of the state government in order to give power to provision of an international treaty. So India generally follows that merely affirming a treaty by way of ratifying it by the assent of the executive, unless the treaty requires ratification by way of an act of the legislature. In the landmark case of Keshwananda Bharti versus State of Kerala, it was observed that the court must interpret the provisions of the Constitution in light of Charter of the United Nations. And there has been an evolution of the philosophy of the role of international treaties, to which India is party to with relation to the Indian Constitution. In case of Magan Bhai Patel versus Union of India, the court held that if a treaty or international agreement restricts the rights of the citizens or modifies the laws of the state, would require to have a legislative measure. For example, if India is a party to an international agreement to stop the killing of a species of turtle, it restricts the right to trade of certain fishermen by prohibiting killing of the turtle. If this treaty is to be enforced in India, the Indian Parliament needs to pass a domestic legislation regarding prohibition of the killing of such turtle species. Furthermore, if no such right is restricted, then it does not need to have a legislative measure to enact it or give rise to some weight in domestic law in the treaty. It is also a very clear of Indian law that international treaties cannot on their own override domestic law. Hence, these treaties which are not enabled by the legislature will not have the same force in the law if there is a contradictory law provided for. However, in the case of Sheila Borse versus Secretary General's Aid Society, the Supreme Court held that India had ratified conventions regarding the protection of children, and this placed an obligation on the state government to implement these principles. This was a case in which there were no contradictory laws, and as they were supplementing the law already in force, the court held that the treaty could be applied directly to Indian law. Additionally, the most revolutionary of these cases was the case of Vishakha versus State of Rajasthan, in which the Indian courts used the provisions of the Convention on Elimination of All Forms of Discrimination Against Women, that is CEDAW, to create legally binding obligations regarding sexual harassment. Moreover, India has dealt with the interplay of international law as fits the need of the day, while any restriction of rights requires the need of an amendment by legislature. Enhancing or broadening the scope of such rights is allowed as long as there is nothing to the contrary or similar in domestic law. Now you must be thinking that these are the matter of law, but when any dispute arises, then how it can be resolved? So in order to understand it, let's discuss dispute resolution method in international arena. So in the domestic scenario, disputes may be resolved by way of various methods, by way of application to court, mediation, conciliation, or even arbitration. However, in international scenario, there may be disputes regarding a large number of issues relating to treaties or some basic convenants of international law. So when such disputes arise between states or even between individuals and the state, there are certain institutions and mechanisms in place to resolve such disputes, and examples of such institutions are International Court of Justice, that is ICJ, and International Criminal Court. So now let's discuss both of them in brief. So the International Court of Justice is termed as the main judicial branch of the United Nations. In 1946, the General Assembly of the United Nations enacted the Statute of the ICJ, which gave rise to the institution of the International Court of Justice at The Hague, Netherlands. All members of the UN are party to this statute by default owing to Article 93 of the United Nations Charter, and non-members may also become parties under this article. The court may have jurisdiction to decide cases in which the parties agree to appear before the court on their own behest and agree to be bound by the decision of the ICJ. The court may also be a forum if provided for in a treaty between parties, and in certain cases it is compulsory to refer to the court with regards to certain disputes. The court may also give advisory opinions under Article 65 to 68 of the Statute of the ICJ to countries. These are not binding but are merely referrals to the ICJ to understand the point of law on the matter. The ICJ is thus one of the primary sources of dispute resolution available with regards to international disputes when parties are agreeable to settle them on their own accord. Now let's discuss International Criminal Court. The International Criminal Court, that is ICC, is a tribunal set up through the Rome Statute in 2002 with the purpose of prosecuting criminals for 4 major crimes. That is crimes against humanity, genocide, war crimes, and crime of aggression. The ICC may prosecute criminals for crimes committed in a country which accepts the jurisdiction of the court. Thus, only if countries agree to submit to the jurisdiction can the ICC take up certain cases in which the person who has committed the crime is a national of the country, or if it was committed in the territory of that country. The cases may be referred by the country directly to the ICJ or through the prosecutor of the ICC, who is the person appointed to try cases on behalf of the ICC. But remember, the ICC has limited jurisdiction over the ICJ with regards to certain issues pertaining to criminal matters listed under the Rome Statute. The divide is similar to the divide of civil and criminal courts in the domestic context. However, the jurisdiction of the ICC is more restricted than that of ordinary criminal courts. In addition to this, there are some other dispute resolution methods, and organization of such methods arise when such agreement is formed. For example, whenever the treaty is entered into by the states themselves lay down the procedure to be followed in case of a dispute. For instance, the General Agreement on Trade and Tariffs provides for a dispute resolution panel within its own provisions. Treaties often employ mediation, arbitration, and other such dispute resolution mechanisms to arrive at an agreeable decision. The United Nations has even created its own forum to deal with issues related to investment disputes in association with the World Bank. So guys, this is end of this video as well as of your syllabus. So wish you all the best. Bye bye.